Who to sue in a defective product liability claim. If you were injured by a defective product, you may want to consider making a claim. Before you even begin the claim process, you will have to identify who is responsible for your injuries, who is liable, and name them as the defendants in your defective product liability claim. Identifying who may be liable is not always easy, however, you should be prepared to search for the responsible party, no matter how long it takes. If you can determine who may be responsible for your injuries, you are more likely to be awarded a settlement. Although the types of defendant that could be held for liable your injuries may differ from state to state, most states recognize that the following could be held liable. The chain of distribution. Every single party involved in the chain of distribution may be found liable. The chain of distribution typically refers to anyone from the manufacturer of the product to the company distributing it, and the company selling it. The manufacturer. The manufacturer may be found liable regardless of the size of the company. If the defect that caused your injury is found to be part of a bigger product, you may want to consider that the manufacturer of the part, and the whole product are liable. You may also want to think about anyone who was involved in the design and marketing of the defective product too. This is because they may be liable for your injuries. The retailer. Although the store where you purchased the product is unlikely to have manufactured it, the retailer could be found liable. This is because they sold you a product that was defective. If this is the case, you do not have to choose between the retailer and the manufacturer, as any party that was involved in the distribution chain could be named in your claim/lawsuit. If you do want to add the retailer to the lawsuit, you should be aware that it's not vital that you purchased the product. For example, if you were given a gift for your birthday and the gift caused you an injury, you could still claim. Neither do you have to be the user of the product. If, for example, a colleague was using a bowl that was supposed to be microwave safe and the product exploded, causing you injuries, you could still have a defective product liability claim. The distributor or wholesaler. Before a product reaches a store, and after it has been manufactured, it may be in the care of distributors or wholesalers. Distributors and wholesalers are part of the large chain of distribution, and could therefore be found liable for your injuries. When a corporation may be liable. A corporation may be found liable as the law considers them to be the equivalent of persons. However, corporations can change in terms of who owns them, the type of corporation they are, and their size and shape. Corporations also tend to merge with others, but they can also be acquired by different companies too and undergo name changes and reorganizations. In some cases, the new companies that have been formed from previous organizations may inherit their liability. This means that they can be named as the defendants in your claim. When the defendants are located overseas. In some cases, a defendant, such as a manufacturer, may be located overseas. This does not mean that you cannot hold the company liable, as when they do business in the United States, they typically render a foreign company subject who is under the jurisdiction of the courts in this country. When there is more than one defendant, not only will identifying as many potential defendants in your case mean it's more likely that you could receive the right amount of compensation, there is also a legal doctrine to consider. This doctrine is known as joint and several liability. What this means is that every single defendant is jointly and severally, together and separately, liable for the damages. If one of the defendants is unable to pay your compensation for whatever reason, it means that the rest of the defendants have to pay for it. Although the defendants may fight about this, it's not something that you really need to worry about. The purpose of joint and several liability is there to ensure that the plaintiff, once and if they have won their claim, will get paid, while every defendant needs to work out how much they will have to pay. For example, if you were awarded $100,000 and there were 4 defendants, they may each have to pay $25,000. However, if one of those defendants could only pay $10,000, the remaining 3 defendants will have to pay what's left. This means that the remaining defendants will have to pay $30,000 each. In the parts of the United States that use joint and several liability, if only one of the defendants can afford to pay compensation, and they were found only slightly responsible, they may have to pay all of the compensation. This is one of the reasons why lawyers try to find as many wealthy defendants as possible. The larger the corporation, for example, the better. Your defective product liability claim. Identifying every single party that may be involved in the manufacture, distribution, and sale of the defective product can be very complicated. This is why if you think you have a claim, you should consider hiring the services of a lawyer who specializes in products liability. The more experienced the lawyer is, the better, as they can help you to understand whether your case is worth pursuing, and how much compensation you may be entitled to.